Welcome to the third edition of the Jean Monnet series organized by the Jean Monnet Chair International Business for European Union. Today we are going to talk about international property line manager with Engineer Roncuzzi from Roncuzzi&Associati, who I would like to thank you for accepting our invitation, and I don't take any time, and I just leave the floor to Engineer Roncuzzi. Just let me remind you that the Jean Monnet Chair is co-founded by the European Commission within the Erasmus Plus program.
Thank you, Professor Sant'Angelo. First of all, I want to thank you and the University of Catania for having invited me also this year for the lecture on intellectual property rights, or IPR, as it's usually spelled in the shortest way. This year, the cut of this 2 days class will be firstly focused on international agreements on IPR, and then, as usual, a more operative part on the same subject, which probably is my best seller. After a degree in mechanical engineering on automation at the University of Bologna, IPR is what I have been dealing with since 1994, when I was hired as patent trainee by an IP law firm in Turin. From an historical point of view, Turin is the place where intellectual property right made the first move in Italy, and a large part of the most qualified IP law firms were born there at the end of the 19th century and at the beginning of the 20th century. In 2002, after some years spent in a big Italian firm in the wellness industry as IPR manager, I decided to establish my own business that turned into Roncuzzi&Associati in 2004. Now, in Roncuzzi&Associati, there are 10 of us, 4 professionals, 2 trainees, and 4 clerks in the secretary, dealing with procedural deadlines. At the end of these 2 days, you will be aware that secrecy is one of the fundamental legs of IPR management. This is our agenda for this 2 days class. Firstly, we are going to spend some time on the principles of the IPR management set up by international and/or national laws, focusing on patents, trademarks, and, if possible, on designs, tools designated to protect human species of creativity in specific areas for determined lapse of time. Secondly, a more practical section follows, dedicated to the tools that allow individuals and undertakings to enjoy of IPRs, namely patents, trademarks, and design models, focusing on the requirements that lead to the grant of patents and to the registration of trademarks and designs. I would like that at the end of this section, you will be put in condition to know what to do when someone, you or one of your clients or colleagues, come up to an invention, a specific sign usable to distinguish goods or services from the one of others, the peculiar aspect of a product. Particularly, when this happens, I would like that you know what to do to assess if it's better to invest on the coming up piece of creativity or give up, avoiding to waste time and money or risking to collide with others' property rights. This would be even more dangerous. Tomorrow, to finish with, you will be assigned a group discussion and be asked to identify the gist of an invention with the aim of turning it into some patent claims and to design a trademark for the specific product which embodies the same claimed invention. Then, you will be invited to present the results of the discussion and Professor Sant'Angelo, if it's the case, to mark your presentation. Of course, it's up to her to decide what to do with this. However, let me ask you what IPR is. IPR is about human creativity. It deals with all the tools that have been made available by international and national agreements to those individuals who are creative and to undertakings where creative people work. International and national agreements provide creative individuals for a type of compensation for their efforts, made to ease the life of others by means of new products or services. Compensation is a right of exclusive exploitation of the results of their creativity, if they turn into goods or services. It lasts for a limited range of time, and it's valid in a determined territory to balance the necessity to award the first mover and leave followers to get on. This is currently a big issue, particularly in the case of patents which ban the free exploitation of inventions representing real breakthrough in the research or in the market. Additionally, compensation is made available to the applicants on condition that they supply complete information about the object of the exclusivity right applied for, and that this object meets specific requirements. Particularly, these tools are patents in the case of inventions, utility model and plant varieties, trademarks for distinguishing signs, logos, words, or shapes, design models in the case of specific shapes of products, external appearance by or three-dimensional, a specific protection for topography of semiconductors, and industrial secrets. We will see which requirements have to be met for having patents granted, trademarks and design registered. Individuals and organizations are allowed to file applications to get their asset registered, no matter if and how seeking for registration is really of use for the applicant. IPR Code do not consider this issue for obvious reasons. I like you to know that IPR has the strongest base in Italy. According to Filarco, an historian who lived in Athens in the 3rd century before Christ, the first patent-like protection known worldwide was launched in Calabria, particularly in Sibari, for a food recipe as of the 7th century before Christ. The aim of this protection, which lasted 12 months, was to promote creativity and increase well-being of the citizens. Whereas the first modern patent was granted in 1416 in Venice for the fulling of wool. Fulling is a specific technique to clean wool and make it more durable. This, behind my shoulders, we see Badalone, which is the invention for which Filippo Brunelleschi was awarded of a patent in 1421 in Florence. The boat was designed to carry heavy loads, specifically large slabs of marble, from the quarries of Carrara to Florence. The invention was carried out, but a disaster occurred to the first version of the boat, so that the invention was not replicated, having been unsuccessful. However, the first statutory patent system in Europe, and probably in the world, was established in Venice on the 19th of March, 1474, during the San Marcos Republic age. The patent could be granted on condition that the inventor disclosed their invention and the protection lasted 10 years. Measures were provided to fight counterfeiting of patented inventions. It might be the case to remember what happened meanwhile. Venezia and her allies were fighting the First Ottoman-Venetian War against the Ottoman Empire shortly after they had captured Constantinople and the last trace of the Byzantine empires. A long time ago, but an international setting very similar to those that we are living now. This statute is one of my favorite readings when I sadly think to the future of our state. So let me read its incipit, because anyone can find here the basis of the modern laws that rule IPR worldwide. By virtue of its grandeur and hospitable nature, it happens that this our city is inhabited and also frequented temporarily by men from different places and astute minds, capable of conjuring up and inventing a wide variety of ingenious devices. And if it were to be ordained that the works and devices invented by them could not be imitated by others who might have spied such ideas, stealing from them the honors, these men would exercise their ingenious spirit and would invent and produce things which would be of no mean use and benefit for our state. We must always bear in mind that when discussing about globalization. Jeremy Bentham and the philosophers of the utilitarianism of the 18th century surely knew the Venetian Patent Act. They came 3 centuries after to develop concepts already expressed very clearly by Italians in different and sometimes really remote ages. However, it's probably their opera that gave a great push towards the modern structure of IPR. Bentham clearly discussed the necessity for government to rely on intelligence and inclination of individuals to maximize the general prosperity. In this slide and in the following, I reported some very interesting notes, really prophetical, at the end of the 18th century. I have chosen 2 of them very consistent with the subject of this class. An exclusive privilege is necessary in order that what is sown may be reaped. In new inventions, protection against imitators is not less necessary than in established manufacturers' protection against thieves. However, the increasing industrialization made the markets every day too small for undertakings, and diversity of laws made it difficult to obtain protection for industrial property rights worldwide. Particularly, as far as patents are concerned, novelty was a critical issue for foreign applications filed in different times for obvious reasons. For instance, due to the impossibility to file an application at the same time in different countries for logistic reasons. A unique strong basis against counterfeiters was every day most wanted. In 1873, at the Vienna International Exhibition of Inventions, the inadequate protection of inventions made the exhibitors not willing to show their inventions publicly. This led government of the Austria-Hungarian Empire to start a political process that led 11 states to sign the first version of the Paris Convention in 1883. Italy was part of the first group of endorsers, together with Belgium, Brazil, El Salvador, France, Guatemala, the Netherlands, Portugal, Serbia, Spain, and Switzerland. And this confirms another time that Italy has always anticipated new trends. I hope it's the same in the future. Since the beginning, the aim of the Paris Convention was to harmonize national treatments of IPRs worldwide, to discipline the tools that assign ownership of invention, distinctive signs, design in each of the contracting states. The Paris Convention set up an effective toolbox easy to be used by those appointed to execute a substantive examination of the object of IPR's applications to check if the requirements for the grant are actually met. Probably the main point of the Paris Convention that deserves to be mentioned is the principle that each country party to the Paris Convention must grant the same protection to nationals of the other member countries as they grant to their own nationals. Another major point of the Paris Convention is the priority right, which is originated by each first application for any kind of intellectual property right. It limits the reference date of prior art that can be used in the substantive examination of a second application sharing its object with the first one. Under the rule of thumb, according to the priority right, The prior art for the substantive examination of a new application, which benefits of the priority right arising from a previous application, must be the same used to assess the grantability of the previous application, even though the filing date of the new one is later than the one of the previous application at the origin of the priority right. Therefore, the priority right stops the time for the grantability analysis of any second application worldwide on the application date of their first application. The only condition for claiming priority right is that this duration is limited. 12 months for patent applications, 6 months for trademark and design applications from the filing date of the first one. It's easy to understand that this right is of utmost importance because undertakings of the contracting states benefit of additional time to plan if and how to expand their IPRs abroad in view of the first marketing response, which obviously comes later than the filing dates of their IPRs applications. Therefore, this right makes investments in IPR abroad potentially more guaranteed and profitable. But who administers the Paris Convention? It's administered by the World Intellectual Property Organization, briefly WIPO. WIPO is the United Nations Organization special agency that deals with intellectual property worldwide. The Paris Convention is obviously subject to amendments as any other international treaty every time that is necessary to take into account new developments of technology or new approaches to creativity. However, the current version and the first one are not so different from what attains to the IPR basic principles. Here you are with the main international agreements that rule IPR worldwide. Now, I refer to TRIPS, which came to light in 1994 to set up fundamentals of IPRs under the wing of the General Agreement on Tariffs and Trades, also known as GATT. Particularly, TRIPS is the acronym of the Agreement on Trade-Related Aspects of Intellectual Property Rights. This agreement was launched together with the World Trade Organization on the same day to set up some principles which are binding for the member states of the WTO. According to TRIPS, a country that wants to be part of the WTO not only must have national laws related to IPR, but these laws have to assure legal certainty for nationals and foreign investors wishing to expand their IPRs there. Additionally, according to TRIPS, the developing countries enjoy more time than others to deploy the TRIPS statutory principles of IPR. TRIPS also specifies remedies, enforcement, and dispute resolution procedures. According to TRIPS, protection and enforcement of intellectual property rights mentioned in the agreement shall contribute to promotion of technological innovation, transfer and dissemination of technology, mutual advantage of producers and users of technological knowledge, in a manner conducive to social and economic welfare, balance rights and obligations. You immediately understand that TRIPS and Paris Convention are complementary. This is a route from the UNO established to the last TRIPS remarkable amendment. You see that everything started in 1945 and the last TRIPS agreement amendment is dated 2007. However, the process was continuous, and I think that TRIPS are very powerful. This map shows the current extension of the piece of earth covered by TRIPS. Almost all the countries that have signed the agreement, apart from certain countries in West Asia and in the center north of Africa, are part of the agreement. Some of the subject matters ruled by the TRIPS reprise the content of rights established by the Paris Convention, but they are revised from a commercial point of view, closer to the US approach than to the European one. Therefore, some of them had to be rewritten subsequently to balance the two different approaches. It is the case of flexibility in circumventing patent rights for better access to essential medicines in developing countries, down through the Doha Declaration in 2001. The chapter pertinent to software and business method inventions suitable to be patented were revised in 2007 in a fashion really closer to the European approach. According to the last version of TRIPS, an application for smartphone, for instance, and all that stuff cannot be awarded of a patent, but it might only be object of a copyright as it were digital literature for computers. As a rule of thumb, a patent protection is allowable for an invention that is a method suitable of being implemented by a computer via software if it's accompanied by a technical effect, namely a tangible and objective result. However, within the countries where TRIPS apply, there is not uniformity in the assessment of patentability for specific subjects, particularly in the US, computer-implemented business methods are often awarded patent protection that wouldn't be granted by European examiners. Neither the Paris Convention nor TRIPS are patent or trademark system, and IPR titles valid worldwide do not exist. Please bear this in mind, because very often people think that it's possible to file a unique IPR application for covering all the countries in the world. Each country in the world has its IPR code, usually harmonized to the Paris Convention and to the TRIPS for those parts that are for those countries that are part of the WTO. Italy issued its Industrial Property Code in 2005 to group previous specialized laws related to patents, utility models, designs, and trademarks, all launched between 1939 and 1941. Here we have a map showing that the Industrial Property Code deals with unregistered and registered IPRs, as many other IPRs in codes in Europe, such as Germany and the UK IPR codes. Groups of states have established governmental institutions to administer unitary procedures leading to IPRs. The United States Patent and Trademark Office, USPTO, deals for patents, trademarks, and design within the 50 US states. The European Union Intellectual Property Office, UIPO, deals with trademarks and designs, but not with patents, within all the 28 EU states. The Eurasian Patent Office, EIPO, which administers unitary patent of the majority of the ex-USSR states. ARIPO and OAPI, which are the reference offices for IPRs in Africa, particularly ARIPO for 18 English-speaking countries and OAPI for 20 French-speaking countries. UIPO has become the new name of the OHIM since March 23rd, 2016, and amendments have been made to the European Union Trademark Regulation, which substitutes the Community Trademark Regulation. You have surely heard about the European Patent Office and of European patents. EPO, as this office is usually mentioned, is not a legal entity of the European Union. It's an organ of the European Patent Organization that is a public international undertaking which is not legally bound to the European Union. In September 1949, French Senator Henri Longchambon proposed to the Council of Europe the creation of a European Patent Office. The Council began working on a European patent law aimed at a European patent. However, the European Patent Office was established later in Munich in 1977 to grant European patents under the European Patent Convention, which is valid in 38 states, comprising each state of the EU considered per se, plus Norway, Switzerland, Turkey, and some others. Each patent application filed at the EPO reaches the grant only after it has passed a formality test and a substantive examination aiming to assess if patentability requirements set up by the EPC are met. If both the examination give a positive result, a European patent is granted. However, it becomes enforceable only after it has been validated in at least one of the contracting states of the European Patent Convention by simply paying a national tax and, in some cases, filing a translation of the text into the local language. Therefore, the enforceability is local and limited to where the European patent has been nationalized. It is necessary to clarify that the EPC is not a patent system, in the sense that it does not deal with counterfeiting. However, in a few months, if Brexit does not take too much, we will enjoy of a bright new European patent tool under the umbrella of the European Patent Office. The Unitary Patent Protection, shortly UPP, which is a European patent with unitary effect. That is to say, a European patent that will be effective in all and only the states of the European Union that have signed the enhanced cooperation. Here you are with a map of the countries that have already signed for the UPP. Currently, only Croatia and Spain have not signed it yet. The UPP entered into force on the 20th of January 2013, but it will apply only after the agreement on a Unified Patent Code, UPC in brief, will enter into force. The UPC will become the jurisdictional authority for European and unitary patents within the EU. Currently, only Croatia, Poland, and Spain have not signed for the agreement. However, it's remarkable that the UPC agreement will enter into force when it has been ratified by 13 statutory states. Territorial effects will expand as the ratification process in the individual contracting member states are concluded. The three most patent-intensive member states, particularly Germany, France, and the United Kingdom, where the three official languages of the EPO are spoken, must be among the states that have ratified the UPC agreement. It might be worth to mention that up to now, out of these three states, only France has already ratified the UPC, together with Portugal, Austria, Bulgaria, Belgium, the Netherlands, Malta, Denmark, Sweden, and Finland. Okay, this is why I said if Brexit does not take too much. Now I think that we can move to the more operative aspects of patents, trademarks, and designs.